Well, we've heard a lot today, and Ms. Terry, just so you're aware, I'm sure Mr. Moustakis has touched on this, but there are factors that the court looks at during sentencing. And the victims need to know this, and everybody needs to know that the law is pretty clear that I'm not sentencing on emotion. This is a case that's local to the community. I don't know that I've seen a case where the interrelationship has been so close. So it's very sensitive, and I want everybody to understand that I recognize that, and that's an aspect of the case. But the law really requires that I look at things, factors. And what those factors are designed to do is take into account what is being said, what was said today. And so I'm going to try to incorporate all of that information in my sentence today. So with that being said, we start with these legality factors. There are a number of them. There are subsets to each one of them. But we look at, first of all, the seriousness of the offense. This was originally charged out and pled out eventually to be a homicide by intoxicated use, significantly less exposure, and that was negotiated between the parties, approved by victims, but it still doesn't change the facts of the case. And this would have been a circumstantial case in a sense if it went to trial. I don't know what happened, Ms. Terry. We have the eyewitness that saw the vehicle from a distance, and when you have circumstantial cases, you have to follow where the evidence takes you. And I've been provided with a number of documents, meaning a criminal complaint. I sat through the preliminary hearings, which transcripts, again, I've reviewed those. The first one was we had it November 14th of 23. We didn't get through with that, so it was on January 16th of 24. And so those are the facts, and then I'm also listening to what both sides have referenced. There's also the pre-sentence investigation version, and then the alternate PSI. So that's the information that I'm going off of, because I don't know what happened. And there's been discussion about intentional, not intentional, whether or not it would have been an element of the crime. But when I look at the pre-sentence investigation, there's a version of events in there that I think are pretty accurate. And again, I'm saying that because of what was testified to, what the evidence showed, the evidence that was left at the scene. There was an inconsistent statement between you. There was this high blood alcohol concentration, and the cause of death. You look at, I didn't see the pictures today. I'm limited on the information that is provided to me, but certainly when you look at the photographs, the testimony that you hear, I looked at the coroner's report, or the pathologist about the cause of death. That was testified to at the preliminary hearing. Blunt force trauma, crushing type injuries to the chest, broken bones, consistent with somebody being run over by a vehicle, these quote-unquote road rash injuries that were consistent. And when I look at the pictures, which I had not seen before today, but those are certainly consistent with that iron bar that was sitting out the back, and consistent with what was testified to. So this 48 feet was testified to as well. I think that's important, and it's an aggravated situation, period. Aggravated. I'm listening to, and this goes kind of towards your character, which I'm going to get to in a moment, but I need to look at this both ways, that in all cases you don't remember what happened. And I've heard and read the extent of your alcoholism, the amount that you drank, and that's the way you function. That was your everyday life. And so there's part of me that thinks that this deniability is on purpose, so you don't have to deal with it. Because somebody that was at your level functioned at high levels of intoxication and would remember something like that, but it's easier just to deny it. There's no doubt about the forensic evidence and the investigation and the scene and what was there and the vehicle and the dents and all this evidence that we're able to rely upon. And so it's an aggravated situation in that sense, and I don't know that I need to find that it's intentional or an accident. The evidence shows that this was more than an accident. And I've seen a lot of these cases in my life, in my career, I should say. The case that Mr. Moustakis referenced with the father and the son, I was the prosecutor in that case. But that evidence went a different way. This does not. This leads to believe that you were the operator of that motor vehicle and hit the victim, dragged for 48 feet, literally ran over, and again, consistent with what the witness said, the sounds that they heard, and that's consistent with what the evidence shows. So it's a very serious offense. It can't get any more serious. We have a victim was killed, left a family, brother, father, friend. So that's as serious as it can get. We also look at the character of the defendant. Mr. Moustakis and Ms. Thompson both set forth a lot of good character traits that you have. You've always been a hardworking student. You did well. You scored the most basketball points, I think, than anybody. You worked your whole life. You have that Midwest work ethic, and those are all good character traits. You've had a difficult life that has been filled with alcohol, difficult. Your mother died when you were 15, young age. And then this just death after death in your family that, and a lot of it was reduced to alcoholism. And that continued with you after the death of your son. I understand how difficult it must be. I've never been through that myself, but trying to cope with that and deal with that. And I don't fault you for going to drinking. That's just the way you did it. And I don't have a problem with that. I think that's appropriate. But the problem is that it literally ran your life. And the relationship that you had with the victim, Donnie, I need to recognize it was volatile. I think that's fair. But he's still a victim. And when you look at the daily routine that the two of you had, going around and you get a 20-pack of bottles and drive the loop, as it's been referred to, that's just the way you did things. And I don't know if you guys argued. I don't know if that's what happened that night. It's, again, it could be just as logical that you got into an argument with him, he made you mad, and so you ran him over with your vehicle. I don't know. But to say we don't have any more information and the evidence doesn't show anything else, it doesn't show anything less either. And so I can't make any inferences on that. And that's why I'm really relying upon what the evidence has shown and the damage. Again, so I don't want to get back to that, but that's part of the character of you. I think it goes positive and negative. We've heard obviously from your family, who paints you in a picture, and we've heard from the victim's family, who paints a different picture. And that's kind of a neutral factor for me. I've seen what you can do and the positive things, but also there are negative character traits as well. Probation is typically preferred. I agree with Mr. Moustakis. I don't think the law allows for any type of probationary sentence. Even if it were, it would not be appropriate. There's also the need to protect the community. And I am surprised that something like this didn't happen before. The way you drank and the way you drove around, your daily routine, that someone in the community doing the same thing that you were doing, except going for a Sunday drive with their family, something didn't happen. This was, quite honestly, something that was going to happen sooner or later, and it did. There's a need to protect the community, always from homicide or from intoxicated drivers. You know, the legislature has made this a mandatory minimum for a reason, because of the severity of the charge itself. They require a mandatory minimum unless there's some compelling reason. And that's important to understand, that that's where you start, is 5 years. So that's a reflection of the legislator trying to protect the community. Rehabilitation. I'm going to separate this because rehabilitation, I'm going to say two things. First, I'm going to tell you about the Mary Terry that was on October 19th of 23. You hadn't received treatment. You hadn't taken advantage of sobriety. You hadn't done anything. That was your life. That's the way you lived it, and which is fine. So I'm looking at the rehabilitation from kind of that standpoint. You hadn't recognized how bad it was. Maybe you did, you just didn't want to deal with it. Again, because of all these issues you had before. Since then, you know, it's been brought to my attention you went through treatment and inpatient treatment. It was voluntary. I can appreciate that. I was a defense attorney at one time. I know the advice that you would typically give clients. But your attorneys are doing their job, okay? And I don't fault anybody, Mr. Moustakis or Ms. Thompson, and you know, as long as I'm going there, the victims need to understand that any defense attorney would have told their client the same thing. So I take the fact that they didn't reach out and do things, I get that, and I don't hold that against her because she was following good, sound legal advice. But the rehabilitation you went through is self-serving, in a sense. After this happened, you decided to get help. Too late. It's obviously assisted you in getting through this. It was the right move. It was the right decision, I should say. But it took killing somebody to get there. And so I just want to be clear that I appreciate that, but this sentence goes back to what happened on October 19th. But I want you to recognize I do understand the treatment. And the rehabilitation in a confined setting in prison is different than what you received up to today. And the law says that if you can receive treatment that's better for you in a confined setting, then that's what the sentence should impose. And this, again, is a mandatory minimum, so you're going to be receiving that rehabilitation in a sense. I'm not sure how eligible you would be for the programming, but I'm sure that they have those types of options. The other factor we look at is deterrence. And there's general deterrence and there's specific deterrence. There are two types. One of the victims made a comment that if you're going to go to Forest County and get into trouble, that you're going to get a slap on the wrist. And that's qualified as general deterrence. Anybody that's watching this case right now and thinks about going out and drinking and driving and killing somebody, they'll know what could happen to them. So there's a general deterrence for the community. Anybody that could potentially do something like this or find themselves in this situation. And then there's a specific deterrent, which is directed right towards you. That if you are ever faced in a situation again, where you can go drinking and then get into a vehicle, that you would look back at this and think, if I do this, something bad could happen, and the deterrent effect works. So there are those two aspects, and I'm taking that into consideration as far as deterrence, and that will be part of my sentence. And then finally, there's punishment. There's a punitive aspect. There's a punitive aspect to this that needs to be addressed as well, and that's where you can look, I think, a little bit more at the emotional part and think about what he went through, what he was feeling. Was he coherent? Did he know? Again, I don't know, but the punishment needs to reflect that. I've heard a lot of information from your attorneys. They've done a nice job setting forth what they feel is appropriate. And again, I've read your PSI, and I've considered your difficult life, the criminogenic results of low. I give that some weight. I've never given those a lot of weight, but I do recognize the suggestion that it's low rate of recidivism, so I'm also considering that. But this case, with these facts and the evidence that I've seen, taking all those factors into consideration, is aggravated. What's sticking with me today that I heard, and I had not made my decision up before coming into court today because I wanted to hear everything, and I did, is, this even from the victims, is this would never have happened if you hadn't been intoxicated. I think that's probably true. But it did, and you were, and I can't accept the intoxication as part of any type of defense. It mitigates it somewhat, and it aggravates it somewhat, and it can be looked at both ways, but what's sticking with me is that it would have been different if you hadn't been intoxicated. But it's still, it's not a maximum case and it's not a minimum case. And I'm not finding there are any compelling reasons to deviate from the mandatory minimum. So, with that being said, I am imposing a 20-year prison sentence that's going to be bifurcated into 10 years of initial confinement, followed by 10 years of extended supervision. I'm going to require that you pay restitution in the amount set forth in the summary. That can be taken out of the bail that was posted, along with court costs. I will give credit for 35 days up front. She's not eligible for treatment or for programming. Did I forget anything, Mr. Seifert? I did costs. Mr. Mustakis, anything further? I thought the PSI said she was not. I think if there's programming available, that's fine. I would approve that, but what I don't want to happen is that she get into, start serving her sentence, and that she get into a treatment program and is released early. If there's a programming that would allow her to, at the challenge incarceration, that she can't be eligible for that until 8 years. Yes.
Very briefly, she'd be ineligible on her age for CIP, and it's a 940, so I believe she's ineligible for ERP.
If she's eligible for programming, that's fine, but not under those two programs is the way I understood it as well. You are required to submit a DNA sample and pay a surcharge, but you also have the right to petition for expungement of that DNA under Chapter 165.77, so 4, if you are eligible. Finally, you do have the right to appeal my decision if you feel I've erroneously exercised my discretion or made an error of law. Mr. Mistakis can go over that document with you. It's your notice of right to seek post-conviction relief. It is time sensitive. I would suggest that you fill it out today, and Mr. Mistakis can file that. Bond is revoked and she will be remanded. Anything else I forgot, Mr. Mistakis? Yes, sir. Madam Clerk, did I forget anything? Yes. All right.
Just on the bond return, that means less cost and restitution, right?
All right, that's going to conclude today's hearing. We are adjourned. I think law enforcement will assist people in leaving the courtroom, courthouse.